Hello everybody and welcome to the course. Apologies in advance if this sound is a bit tinny. It's the first time using a lot of this recording software for some of the teachers, so bear with us. I promise it will get better over time. So welcome to IlmLearn. This week will be an introduction to Moodle and an introduction to the syllabus which you will be studying. So, Cambridge International Advanced levels are widely recognised across the world. And what that means is, when the time comes for you to be thinking about university applications or perhaps studying here in the UK, it means that all universities will recognise them and say, yep, Cambridge International A-levels, we can allocate a certain amount of UCAS points or external points for them in order for you to get onto the programmes. So I imagine there will be similar introductions from your teachers for business and economics this week, but this will be an introduction for your law subject. So with this in mind, in your AS Year 12 year, we will have three main topic areas or study areas. So for those of you that are the keen eagles out of all of you, you probably will have had a quick peek through the syllabus, and this is what we're going to be having a scan through today. So the first topic is known as the sources of law. So not to be confused with other types of sources, sources of law really drum down into some key areas. We have, for example, our common law. Our common law is very much this idea of law that's developed by judges through time. So particularly in the UK, some of our case law can go back hundreds and hundreds of years. Alongside that, we have what's known as equity. So equity, back in the olden days, we had two types of courtroom. We had the common law courtroom and we had equity as well. So equity is another branch which no longer in the UK do we have that separation, but certainly today we still have lots of equitable principles. So for example, if you and your partner were to buy a house and only one of you paid the deposit, but the other person, let's say, paid the bills and did the vast majority of, let's say, lots of house or building work, then under equity that ownership of the house would pass over to the other person as well, or rather a share of that ownership. So equity will be looked at as well. And of course, to get an idea of how law developed or what law is, we will look at some of the natural laws, or what we refer to as the original laws, or the natural law. And what this means is it's kind of law from the Greek times or the Roman times or the medieval times, and very much has ties into for example, religion. So obviously commonly known as the commandments, your 10 commandments, and a lot of that law is tied into religious, or what we refer to as canon law. So we'll be having a look at where a lot of that developed from. And of course we will look at what we refer to as the doctrine of precedent. So the doctrine of precedent, if you imagine a case that was decided 200 years ago, let's say it was to do with somebody who was stealing. Now at the time, somebody who's stolen, let's say they got a fine of 5 shillings. Over time, as things change, like currencies or the status of citizens, for example, if people get the right to vote, as happened in the UK in the earlier 20th century, it was extended to women and the lower classes. So as times change, we look at laws and we say, perhaps this isn't what we thought, this isn't really what we thought would suit perhaps citizens or society down the line. So what we then do is we develop this idea of precedence. So as time goes on, just so that you can say, right, if I do X offence, if I go to Y court, then I will have the same outcome. Now, there's nothing worse, as used to happen in the olden times, is let's say you got tried in London for theft. and you got a sentence of 2 years. But if you got tried in Nottingham or Leeds or Manchester, then you got 10 years. Now obviously this wouldn't make sense, so what people used to do in the olden times, they'd skip and go to different courts or countries or counties rather around the UK that would basically offer a more lenient sentence. Now as time went on, we used to have people that would go around like journalists, and they go, okay, in this case X has been given 5 years for theft, or Y has been given 4 years for theft. And these are basically our law reporters. So some of the most common one might be All England Law Reports or ICLR. And these are just names that we give to, over time, big books of reported cases. Now over time, these publications were made more general, and they were made more available to other people, and judges started reading them, and professionals and lawyers. And over time we started to have this idea of, okay, a decision in Nottingham should be based on the same legal principles as a decision in, let's say, London. And this is where we had this idea of precedents develop. So that if a case had said, okay, you're getting 5 years for theft, then that would generally be followed throughout all of the other cases and all of the other sentences. And over time, this also developed to the types of law. So, for example, if you could blame, let's say, intoxication. So let's say you could say, oh, I haven't committed theft because I can't form the mental element of the offence because I was intoxicated. Then what was allowed in one court would then pass throughout the other courts, so that we had real consistency. And if you think about that, that's really important, because if you're charged with an offence, you want to know that wherever you are in the country, you're going to get the same treatment, and they're going to be using the same rules and the same laws, and that's what we call precedent. So where do you think the most suitable place might be to write laws? If you guessed it, well done, in statute books or big law books. So quite commonly in the UK we have big statutes, there's lots released every year, and they contain the laws, and this is what we call statutory legislation. And these are laws almost like book laws or laws, because in the UK the people operate in a democracy, which means that the people will elect a government. Now the government is effectively a political party, and these political parties, based on how many votes they get from the people, will have a different number of representatives in what we call Parliament. So Parliament's made up of two. We have our Houses of Parliament, or our House of Commons, and we have our House of Lords. So the House of Commons is made up by elected representatives, and they will discuss and make the law. When they've made the law, that will then get passed on to the House of Lords, for example. Could go the other way around. And the House of Lords will then consider that, and it will go back and forth a bit like ping pong. And over time we will develop a law that will say, yeah, we're happy with this, for example, the Offences Against the Persons Act, and we'll say, there we go, that's enshrined in law. Now all of the judges, because judges aren't elected, judges must follow this law. It's what we call the highest form of law. Now sometimes these laws can be quite old, or they can be quite complicated, or they can be quite confusing. So what this means is, over time we have certain tools to interpret the statutes, and this is what we call statutory interpretation. And what this allows us to do is we can say, okay, I think the judge meant this, or I think the judge meant that, and it allows the judges to give, sorry, not the judges meant this, but rather the Parliament or the lawmakers meant this, or the lawmakers meant that, and that gives the judges a better opportunity to give effect to the law and make sense of it. And as I mentioned, that's called statutory interpretation. Next, and one of our final topics on sources of law, which is topic 1, we'll look at delegated legislation. Now if you think about how many laws apply, not only statute but case laws and bylaws. So bylaws are, for example, saying to councils you can have speed cameras that stop certain speeding in certain areas, or you could say, okay, there's bylaws for parking in certain areas, or there's bylaws to certain medical hospitals that say, okay, you can make the rules in relation to X, Y, Z. These are what we call delegated legislation, or this is where the main lawmakers create laws or statutes that then allow others underneath it, they're enabled to make laws of their own. That's a very interesting topic. The penultimate topic for sources of law is to do with human rights. So human rights, as we've probably all heard of, are very much tied into the European Convention of Human Rights. And these are things like the right to a family life, the right not to be tortured, freedom of speech, things like that. And as we'll learn over time, some of those rights are what we refer to as absolute. They cannot ever be broken. And we've got some of those which can be qualified. Things like freedom of speech. Generally, governments aren't too happy about allowing freedom of speech if, for example, it's inciting things like terrorism or causing harm to others. So this is where we always generally have a caveat or a threshold or a barrier to the right. Finally, we will look at the law reform, or most commonly in the UK, what we refer to as the Law Commission. So the Law Commission will set up and devise with one aim in mind, to make sure that all of the law we live with today is fit for purpose, it's modern, it's appropriate for our society. So, for example, they might look at very old laws. For example, in the law of provocation, this was the idea that if somebody provoked you or caused you to get angry, so you hit them, that generally that might be a defence to something like murder. You could say, look, I was provoked. I didn't intend to murder them. I was acting in a reaction. And they might come along and say, yeah, it's too old-fashioned, we don't want that, we might update it, which is what they did most recently with the Coroners and Justice Act. They took provocation and said, no, it's too outdated, it's too old, it needs updating, and they brought in a couple of things, one of which is loss of control, the other one is diminished responsibility, which has a lot more clearer guidelines. So that brings our sources of law, topic 1, to an end. Then we get on to the fun stuff. So topic 2 is referred to as machinery of justice. This is where we're looking at the courts, we're looking at the process. We're looking at, okay, what do we mean by a county court? What do we mean by a magistrate's court? What is a high court? What is a court of appeal? What is the Supreme Court, or you might have heard the House of Lords? We're looking at it actually set up and what it means to us. And we're really looking in detail at the different processes. So where would a claim for £50 million start out? Would it start out in the magistrates? No, it wouldn't. Would it start out in the county court? No, it would most likely be in the High Court, where all the serious, large, complicated cases start. We'll then be looking at, okay, does it have to end up in court? What happens before court? So, for example, in civil disputes, I've been involved in a lot of these recently on behalf of people. This is about trying to find agreement, what we call ADR, or alternative dispute resolution. So we'll be looking at things like mediation or conciliation or arbitration. And these are all things where we're saying, okay, let's all get together and let's try and come to a conclusion for this case. Because as I'm sure you'll agree, sometimes going to court isn't the best option. It could be expensive, there's a risk you lose. So ADR is actually actively encouraged nowadays. Then we will be looking at the actual process. So in case you haven't gathered already, we have in a way two kind of legal systems which operate in tandem in the UK, or England and Wales. We have on the one hand civil courts. So the civil is to do with civil wrongs, things like breach of contract or negligence or medical malpractice, or you not paying for a car you've damaged, or you not paying a bar bill, or you not paying for the football for the football pitch you rented. These are all tied typically between individuals or organisations or businesses, and we'll look at the kind of process for that. On the other hand, we will look at the criminal process. So in this country, in England and Wales, all criminal prosecutions are brought by the Criminal Prosecution Service, or what we refer to as the CPS, and they're actually brought on behalf of the Crown, or the Queen in this case. Obviously we've got a Queen in England and Wales at the moment. If it was a king, it would be brought on behalf of the king. So we'll look at the process there, where cases start. All cases start in the magistrates' court, whether they've got to go up to what we refer to as the Crown Court. So these are things you've probably seen in television, with the judge with his wig on, and counsel or the barristers arguing the points, and the jury. These are all things to do with the criminal courts. So we'll look at the criminal courts and we'll look at the criminal process in detail. Then we will look at what happens if a person's convicted. So what if a person's found guilty? What kind of principles, what kind of sanctions do we have? So a couple of hundred years ago we had penal colonies. If people were bad or people were criminal in England and Wales or the UK, they'd be sent to Australia. They'd be put on a boat, see you later, never seen again. Likewise, they'd be put in prisons and they'd be locked away and have to do hard time. Now as time went on and things developed and society grew and society changed, suddenly it was, is that the best way of dealing with offenders? Are offenders to blame? Is it more the society's responsibility to reform the offenders? So suddenly sentencing took on a couple of different aims. It was no longer just to punish. It could be to act as a deterrent, to stop other people committing offences, or to perhaps stop that individual from going back and committing that offence again if it's been punished. It might be to reform them, so to perhaps get them into prison so that they could learn a new trade or learn new skills. Also, it could be to physically get them off the streets, to get these criminals who are costing the state lots of money, robbing and stealing, or causing harm to society. It was physically going, right, you're in prison, you can't do that anymore. So these are all the different aims or the theory behind sentencing, or the guides. We'll also look at what happens with perhaps particularly young people. So if you're 14, 15, it's not worth putting someone in prison. We can't in this country. It's more to do with trying to reform those children, perhaps with the use of an ASBO or antisocial behaviour order. And all of these things aim to stop the problem in its tracks, to say, hang on, let's do something about it now. So often at the younger ages it's more about reforming the children, or reforming the young adults, as opposed to punishing them. So that then brings us to the final third of the year, or the final topic of the year, and this is my favourite and what I find is probably the easiest topic, which is legal personnel. So legal personnel, we'll be having a look at what do we mean by a lawyer. So in many countries they don't have a difference between, for example, a barrister and a solicitor. They just refer to them as lawyers. In this country, a lawyer is kind of what we describe the whole group, whereas we've got very special differences between a barrister. Usually the people in wigs you see in the High Court or on television, very clear, giving the case, you know, very well spoken, very articulate, and they're very good at putting points across. And that's the route I went down, so I studied the barrister route. Or on the other hand, you've got the solicitor route. So these are people that would be perhaps more likely to write letters, or deal with businesses, or deal with individuals, and do all of the hard work in the run-up to the case. So they'd be the ones that, for example, might write to you and say, okay, we found you in breach of this contract, we want X, Y, or Z in return. Very different skills. The route's fairly simple in that obviously you've either got to do a qualifying law degree such as an LLB, or you've got to do the GDL, which is effectively a conversion course. One of them's 3 years, the other one's 1 year. And then you go on to study either the LPC or legal practitioner course for solicitors, or the BPTC or Barrister Practitioner course for barristers. They both cover fairly similar topics such as advocacy, whereas barristers might concentrate more on cross-examination, re-examination, examination in chief, opinion writing. Solicitors might concentrate more on, for example, drafting, and that's where the differences really start to show. We'll then look at different types of legal personnel relating to the judiciary. So who are judges? Where did they come from? What are their qualifications? Why are they good or bad at what they do? What makes them who they are? What's the training behind them? We'll then, as I mentioned earlier, look at the CPS, the Crown Prosecution Service. What makes them up? Who are they? Who do they represent? Which will tie in quite nicely to topic 2, machinery of justice, if you've already, if you remember and recall earlier of me mentioning them then. We will then look at the role of lay personnel. So what lay personnel, a lay person is somebody that's not legally trained or legally qualified. So lay personnel are things like lay magistrates. Did you know that nearly 99% of all cases in the UK are decided by lay magistrates? These are people without any legal qualifications, and that's because most cases are fairly simple and basic. For example, most parking or driving offences, or dangerous driving, or even most common assaults are usually all dealt with the magistrates. So magistrates will look at what makes them up. We'll also look at lay personnel in the Crown Court. So typically this will be our members of the jury. So what allows you to be a jury member? So totally by random. Things what might disqualify you and what your duties are. And finally we'll finish very shortly looking at the Lord Chancellor. And this is an area of the law that's seen a lot of change. The Lord Chancellor is a very important position within the law. So we'll look at the changes, the roles and responsibilities of the Lord Chancellor, particularly over the last couple of years that's seen a lot of change. So all in all, just to recap, we have sources of law, topic 1. This is very much an introduction. It shows us the types of law and what law is and where it comes from, how it changes, how it develops over time, which should take us just past Christmas. We'll then have the machinery of justice. So this is okay. If we've done the theory and the basics, what does it mean in terms of doing it, or how does it work as a process? So this is looking at the different courts and looking at how it all comes together. And finally we look at the what, the who, and this is legal personnel. So after we finish topic 2, probably early next year, we'll be moving on to legal personnel next spring, summertime. And this is looking at, your barristers, your solicitors. And for any of those out there that want to go into law down the line, this is an area you'll really find interesting. It's a very simple area, and it's very, very unique in the fact that in England and Wales we have barristers and solicitors, and we've got such a traditional and historical legal background, and that's something that's really exciting. So we look at things that can go back hundreds and hundreds of years. For example, my Inn of Court, Lincoln's Inn, can trace its roots back over 800 years, which is a long, long time. So I hope you found all of this information useful. Have a little look around Moodle, try and get used to things, and from next week we will have some set lessons introducing you to some of the first topics, and we'll have some activities and an opportunity for you to introduce yourself and get to know your peers. Currently we've got around 15 to 20 students, and it'll be really great just to get to know them. Some of the work will be activity based and just get you into this process of learning in an effective and interesting way. So I promise you I will try and make the law as interesting as possible. I've been teaching it a long time now. I've got lots and lots of years experience. So with a bit of luck, if you work hard, we will get the very best results we can. So once again, thanks for tuning in. Thanks for watching this through to the end. If you have any questions, just pop an email. We'll be sending you out the relevant topic or subject specific emails later this week. But to give you a clue, I think it's law@ilm-learn.com, business at ilmlearn.com, obviously with a dash, and finally economics at ilm-learn.com. So that will put you in direct contact with your teachers, or likewise there is a messaging service online which you'll see as well. But don't worry for now, everything will come through slowly but surely. Just stick with it and I promise you things will get easier. Okay, can't wait to speak to you all soon and get cracking with all our lessons next week. Take care, bye.